Prince Harry gave evidence last week in his high-profile case accusing Associated Newspapers Limited, A&L, publisher of Daily Mail and Mail on Sunday, of unlawfully gathering information relating to their private lives.
He was very much angry, very much frustrated. The judge intervened 3 times during his testimony.
The room didn't react at first, and that's what made it unsettling. Inside a sealed London courtroom, with no cameras and no audience noise to soften the moment, Prince Harry sat under oath when a judge asked a question so basic it barely registered as important. It wasn't accusatory, it wasn't emotional, it was procedural. The kind of question meant to anchor testimony before anything complicated begins. The full birth dates of his children. Seconds passed. Not many, but enough. Enough for the air to shift. Enough for attention to sharpen. Enough for the silence to stop being empty and start meaning something.
I was trying to almost argue back against the barrister, so he appeared very much frustrated, very much angry.
In court, pauses are never neutral. They aren't read as thoughtfulness, they're read as hesitation. And hesitation under oath doesn't fade. It leaves a mark. That brief gap, no words, no correction, no immediate answer, quietly became the most important moment of the day. Because when a story relies on credibility, silence can be louder than a mistake.
Did not relate to Meghan whatsoever, and he said at the end with a cracked voice, holding back tears,
"This wasn't a trick, and it wasn't designed to trip anyone up." Courts begin testimony with verification for a reason. Names, dates, identities, they establish certainty. They ground everything that follows. Parents don't prepare for these questions because they don't need to. These details live in muscle memory, not paperwork, especially for someone whose public identity has been built around fatherhood and protection. In a courtroom, clarity on simple facts signals reliability on complex ones. That's why the expectation was immediate. No legal maneuvering, no interpretation required, just confirmation. And when that confirmation didn't arrive, the court didn't rush to fill the space. Judges don't rescue witnesses from silence, they observe it. Every second without an answer subtly reframes the witness, not as someone thinking, but as someone calculating, uncertain, or struggling to anchor themselves to the facts. What should have taken a breath took too long, and once that happens, the court doesn't forget. It adjusts how it listens. In everyday life, forgetting something personal can feel harmless. In court, it's dangerous. Judges don't evaluate stories the way audiences do. They evaluate consistency, timing, confidence, the spaces between words. Silence under oath isn't empty. It creates room for doubt, and doubt spreads. When a witness hesitates on a foundational detail, it forces the court to quietly ask a question it never wants to ask. If this isn't solid, what else isn't? That's why no one interrupted. No lawyer jumped in. No clarifications softened the moment. The silence stood on its own. And from that point forward, every answer that followed would be heard through its echo. This wasn't about forgetting a date. It was about losing momentum, losing narrative control. Once that control slips, the witness is no longer leading the story. They're reacting to it. And in a judge-only trial, reaction reads as weakness.
Saying as I said before, they've made my wife's life absolutely miserable was the quote.
To understand why that hesitation carried so much weight, you have to look at where it happened. This wasn't a symbolic appearance or a media moment. It was a return to the very system Harry had publicly criticized for years. No royal procession, no public reassurance, no familiar buffer. He arrived quietly, alone, and noticeably without Meghan Markle by his side. Inside that courtroom, status didn't matter. Past grievances didn't matter. Only procedure did. The setting itself stripped away narrative comfort. Heavy doors, neutral tones, no emotional cues, just facts. And the body language reflected it. Not panic, but detachment. Not confidence, but endurance. This wasn't a man preparing to persuade. It was a man bracing to get through the day. That matters because posture sets perception. Judges notice when a witness appears already worn down, already defensive, already carrying the weight of years of conflict before a single question is asked. The silence didn't come from nowhere. It arrived in a room where control had already begun to slip. This case was never going to be decided by one document or one explosive revelation. Its foundation was far more fragile. It relied on recollection, patterns, timelines, personal memory stretched across years of alleged intrusion by the press. That kind of case lives or dies on internal consistency. Dates must line up, sequences must hold. One moment has to logically lead to the next. In a jury trial, emotion can sometimes bridge small gaps. Here it couldn't. This was a bench trial, a judge measuring reliability, not resonance. And that's why the earlier silence mattered so much. It wasn't damaging because of what the question asked. It was damaging because of what it revealed. If memory falters on something deeply personal and foundational, the court is forced to treat every later recollection with caution. The story doesn't collapse all at once. It weakens quietly. And once that weakness is visible, the pressure doesn't ease. It compounds. By the time testimony moved forward, the courtroom was no longer listening passively. It was measuring. That shift became unmistakable when Harry was asked to read portions of his own witness statement aloud.
How he was going to be referred to, whether they refer to him as His Royal Highness. Of course, that HRH title should remain inactive as he's not a working member of the royal family.
On paper, the words had been carefully chosen, refined by legal teams, and framed to explain years of distress caused by relentless media attention. Spoken out loud under oath, they landed differently. His voice stayed controlled, but the rhythm changed. Certain lines slowed him down. Not because they were hard to read, but because they were hard to own. He described how prolonged stress and fear affected his ability to recall events clearly during the early years of his children's lives. In that moment, the earlier silence snapped into focus. What had seemed inexplicable now had context. The hesitation wasn't isolated anymore, it became part of a pattern. And courts don't ignore patterns. They trace them. This was where the balance became delicate. Vulnerability can humanize a witness, but it can also complicate credibility. The court didn't react with visible skepticism or judgment. It reacted with restraint. Judges are trained to separate emotional truth from factual certainty. A person can be wounded and still be honest. But when emotional explanations begin to blur timelines, reliability starts to wobble. The problem wasn't that Harry acknowledged memory gaps. It was that the case depended on memory being precise. The more he explained why certain moments were unclear, the harder it became to treat his recollections as anchors rather than impressions. Sympathy didn't vanish, but it stopped being helpful. And in a judge-only trial, help doesn't come from empathy. It comes from clarity. Then the tone of the room shifted again, this time quietly. Another witness took the stand, and there was nothing dramatic about her presence. No tension, no visible nerves. She didn't speak with urgency or emotion. She spoke with ease. Her testimony focused on a specific article central to the case, one Harry claimed could only have been written through unlawful means. Timing was everything. According to his account, the information appeared in print before it could have been known publicly. Her account disrupted that certainty. She described overhearing details in an ordinary setting, a private lunch where journalists exchanged information openly. No secret methods, no intrusion, just conversation. More importantly, she placed that exchange earlier than Harry's sworn timeline. The contradiction wasn't explosive, it was surgical, and that made it powerful. In court, delivery matters almost as much as content. This witness didn't defend her memory. She didn't qualify it, she didn't hedge. She recalled events the way people recall routine professional moments, without strain. That contrast mattered. Harry's testimony was shaped by years of conflict, emotion, and personal stakes. Hers wasn't. Judges don't reward passion. They reward consistency. When two memories collide, the one delivered without visible effort often carries more weight. Not because it's guaranteed to be right, but because it appears unburdened. The room felt it. Questions adjusted. Attention sharpened. The case was no longer about whether the press had crossed a line. It was about which version of time held together under pressure. Then came the moment no one could soften. Asked to clarify a detail, the witness paused briefly and said, calmly, "I don't think he remembers saying it." The words weren't aggressive. They weren't accusatory. They were observational, and that made them devastating. Across the room, something shifted. Harry's composure faltered, just slightly. A pen slipped from his hand and struck the desk. It wasn't dramatic, it wasn't loud, but it didn't need to be. In a courtroom built on control, small breaks carry enormous meaning. That sound marked a loss of grip, not just on an object, but on the narrative itself. From that point on, the case no longer felt balanced. One side was recalling, the other was explaining why it couldn't. What made this moment irreversible wasn't embarrassment, it was implication. Courts don't punish people for imperfect memory, but they do recalibrate trust when inconsistencies stack up. The silence at the beginning, the admission of blurred recollection, the conflicting timeline. Each one alone might have been manageable. Together, they formed a pattern the court couldn't ignore. From that point forward, Harry wasn't just presenting a case. He was being evaluated as a narrator whose grip on his own story was weakening. That evaluation doesn't happen out loud. It happens internally, in the judge's quiet recalculation of weight and balance. Once that recalibration starts, it rarely reverses. This wasn't about catching someone in a lie. It was about control. Courtrooms reward witnesses, who remain anchored even under pressure. When answers come quickly and consistently, they project authority. When explanations multiply, authority drains away. Harry didn't lose control because of a scandal or revelation. He lost it because memory became unstable. And in a case where memory was the bridge between accusation and proof, instability was fatal. The law doesn't ask for perfection, it asks for reliability. And reliability, once questioned, is almost impossible to restore mid-trial. Looking back, everything traced itself to that opening pause. The moment the court first realized certainty wasn't guaranteed, that silence didn't prove anything on its own, but it framed everything that followed. It changed how questions were heard, how answers were weighed, how contradictions landed. By the end of the proceedings, the case wasn't collapsing loudly, it was thinning, quietly losing density. And that's often how cases truly fail, not with outrage, but with erosion. So what did that silence actually reveal? Not forgetfulness, not guilt, but vulnerability in the one place the law can't tolerate it. The courtroom doesn't judge character, it judges consistency. And once consistency cracks, even slightly, the entire structure shifts. Whether pressure, trauma, or exhaustion caused that moment is something only Harry knows. But what the court saw was simpler and more unforgiving. A story that could no longer fully hold itself together. And in a legal battle built on memory, that may have been the most damaging revelation of all.